The Judiciary will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on presidential obstruction of justice and abuse of power. Before we begin, I would remind all our committee members that we should refrain from making inappropriate personal references to protected parties, namely the President, Vice President, members of the Senate, and members of the House. This would include accusations of dishonesty, criminality, treason, or other unethical or improper motive. The critical issues we are addressing today, which go to the very core of our constitutional democracy, understandably bring out strong passions in us, as they do in the American people. But I hope that in what should be a spirited discussion of these issues today, we will stay focused on the issues and take care to keep our comments from being directed personally toward the President. I will now recognize myself for an opening statement. Today's hearing is entitled Presidential Obstruction of Justice and Abuse of Power. This hearing is the first one formally designated under the committee's procedures adopted last week in connection with our investigation to determine whether to recommend articles of impeachment with respect to President Trump. We subpoenaed 3 witnesses to this hearing: Rick Dearborn, Robert Porter, and Corey Lewandowski. Unfortunately, we learned last night that the White House is blocking the first 2 from even showing up and tightly limiting the third. The White House has no authority, legal or otherwise, to give these orders. We had wanted these 3 individuals to testify before the committee and the American people because they are critical witnesses to the incidents of obstruction of justice laid out in the Mueller report. In at least 5 of those episodes, evidence laid out in the special counsel's report established that all the elements of obstruction of justice were met. Today, despite the roadblocks the White House has thrown up, we will focus on one of the most concerning of those 5 episodes. It is the President ordering the Attorney General, through Mr. Lewandowski, to stop the special counsel's investigation into the President and his campaign. As the report detailed, Mr. Dearborn was enlisted as part of that effort as well. Mr. Porter has other critical evidence regarding obstruction. As our hearings with the special counsel and other outside experts established, anyone else involved in these episodes of obstruction would have been charged with a crime. Anyone else. Let that sink in. The President knows this, and the White House is intent on preventing the American people from hearing the details. So it is no surprise that the White House blocked 2 of our witnesses, Mr. Porter and Mr. Dearborn, from showing up at all today. On behalf of the President, the White House and the Department of Justice are advancing the same spurious legal doctrine they did when this committee called on the most important obstruction witness to testify, former White House counsel Don McGahn. They claim Porter and Dearborn, like McGahn, are absolutely immune from testifying before Congress. There is no such thing. The only court ever to consider this purported absolute immunity doctrine totally rejected it. That is why we have gone to court in the McGahn case to set it aside. What is happening today is more troubling than McGahn's failure to appear, because even if we apply DOJ's own made-up rules of absolute immunity, I question how Mr. Dearborn fits under those rules. According to DOJ opinions, absolute immunity applies to, quote, the President's immediate advisors who serve as the President's alter ego, close quote. To extend this already dubious doctrine to someone like Mr. Dearborn, who is far more removed from the President than McGahn, is a dangerous new stretch. I think we should call this what it is: an absolute cover-up by the White House. Mr. Lewandowski is here and has vital information about presidential obstruction of justice. But the White House wants to limit our and your ability to hear it all. Mr. Lewandowski was called alone, one-on-one, into the Oval Office on June 19, 2017, and again on July 19, 2017. And the President did something I find startling. He dictated the speech to Mr. Lewandowski, a speech not for Mr. Lewandowski, but for Attorney General Sessions to deliver, then Attorney General Sessions. He secretly told Mr. Lewandowski to put the following words in the AG's mouth, quote, I am going to meet with the special prosecutor to explain this is very unfair and let the special prosecutor move forward with investigating election meddling for future elections so that nothing can happen in future elections. That quote is from Volume 2, page 91 of the Mueller report. As the Mueller report found, limiting the investigation to future elections would have cut off the investigation of any past conduct and struck at the heart of the special counsel's mandate. It would have ended the investigation of the president's conduct. The evidence found by the special counsel met all the elements of obstruction of justice. Mr. Lewandowski was nervous about this demand from his former boss, as he should have been. It raised serious questions about criminal conduct. He was recused, forbidden from doing anything regarding the Mueller investigation. He was certainly not allowed to curtail it. So Mr. Lewandowski tried to surreptitiously meet with the AG. When that failed, he tried to pass the buck to Mr. Dearborn. Mr. Lewandowski gave Mr. Dearborn the script that had been dictated by the president, all while telling the president that he would follow through on the president's orders. So that is what we want to try to learn more about today. As we learned with Special Counsel Mueller, witness testimony is critical to any investigation. But the White House does not want us or the American people to hear this story in full. Late yesterday, the White House sent us a letter claiming that Mr. Lewandowski's conversations with the president, quote, are protected from disclosure by executive branch confidentiality interests, close quote. They say he may testify about presidential communications that are already disclosed in the Mueller report, but no more. They make that claim despite the fact that Mr. Lewandowski was at all times a private political operative, apparently was not offering advice of any kind, the usual prerequisite for executive privilege, and was enlisted for apparent wrongdoing. No court has ever said that the president is entitled to confidentiality under these circumstances. Indeed, the Department of Justice has said executive privilege should not be invoked to conceal evidence of wrongdoing on the part of executive officers. The White House is advancing a new and dangerous theory, the crony privilege. It makes absolute immunity look good by comparison. Where are the limits? This is a cover-up, plain and simple. If it were to prevail, especially while the Judiciary Committee is considering whether to recommend articles of impeachment, it would upend the separation of powers as envisioned by our founders. And today's cover-up is part of a pattern of the White House blocking Congress. The president announced his desire to, quote, fight all the subpoenas, unquote. The White House's obstruction of Congress ranges across nearly every committee and virtually every investigation of the administration, whether related to children in cages, botched security clearances, or their failure to defend the country from ongoing attacks by a foreign adversary. Well, Mr. Lewandowski, you are here under subpoena, and that means you are required to answer our questions, all our questions, completely and truthfully. Our investigation also extends beyond the four corners of the Mueller report. We are looking at corruption and abuse of power more broadly, so we will inquire about other subjects as well. We will not be daunted by the cover-up. We intend to secure accountability for any wrongdoing, because no one is above the law, not even the President of the United States. I now